All right. All right. Hello and welcome. Hello and welcome. Welcome, everyone. Thank you so much for being here. Welcome to another episode today of the Empowered Immigrant Live. All right. My name is Otis Landerholm. I'm a certified specialist in immigration law, and I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And so thank you for being here. All right. Today, our topic is how to prepare for immigration court. And specifically, we're talking about master calendar hearings in court. All right. The very kind of the basics. All right. Let's get back to basics today. And so thank you for being here. Thank you for tuning in. Remember, the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. Okay? And so today our theme is how to prepare for immigration court. And, my question always is, do you want to get a green card? Do you want to apply for asylum? Do you want to at least see what the best strategy is for you, what the best options are available for you, or how to maximize your chances of success in your immigration case? Because if so, go for it. And I'd love to help you with that. All right, my firm is on a mission to win 10,000 immigration cases in the next 10 years, and we would love for your case to be one of them. All right, so thanks to everyone for being here. As I talk about my topic, if you have questions, feel free to submit them. And I really appreciate everybody for being here, whether you're on YouTube, Facebook, LinkedIn, Instagram, TikTok. Thank you so much. Welcome. I appreciate you joining us here today live on the Empowered Immigrant Live. All right. So we got lots of news, of course. It's April of 2025. Trump has been back, I believe, 9 weeks now in the White House. A lot has changed. The Laken Riley Act was signed into law. ICE is getting going with its mass deportation efforts. The Senate and the House have approved the Trump budget for that, which will include raids and more detention facilities and all of that stuff. They've announced a registration requirement, okay, which was supposed to go into effect on April 11th. There has been a lawsuit filed challenging it, and so we'll have news about that as that lawsuit moves forward. All right. DHS fired the acting director of ICE. They hired new leadership or put in new leadership. They've fired many immigration judges. They're still talking about a new travel ban. All right. They've deported people under the Alien Enemies Act, which is like a wartime law. Anyway, there's lots of crazy things happening. Okay. Lots of crazy things happening. And so I want to kind of let people know of the crazy things as they are happening. And so to do that, hey, please continue to join us here on our Empowered Immigrant Lives, and welcome to our conversation today. All right. As I'm talking, feel free to submit any questions that you have. My theme today is, okay, how do we prepare for court? How does a good lawyer prepare for a master calendar hearing? And how does a person prepare for a master calendar hearing? All right. And so, imagine that you're showing up to court. You're at your very first hearing in immigration court, okay? And imagine in your courtroom there's 30 other people that are all there too. And the judge is calling each case up one at a time. And each case, it's super fast, right? 5 minutes, maybe 10 minutes per case in front of the judge. All right? And imagine that your lawyer's there with you, and your lawyer says something like this. All right? Hello, Your Honor, good morning. Nice to see you. All right? We're ready to take pleadings today. Okay, are you counsel? Thank you. How do you plea? We'll admit allegations 1, 2, and 3. We'll decline to designate a country of removal. And we're going to submit an application for asylum, withholding of removal, and relief under the Convention Against Torture because my client is afraid for his life to return to his home country. Right? Like imagine more or less something like that is said in the courtroom. And then the judge says, okay, counsel, good to see you. By when will you submit the application for asylum? Your Honor, thank you. Give us 60 days. Okay, great. We'll reset the case, and after that, well, first we'll set it for a master, and then after the application's received, we'll reset it to an individual hearing. All right, something like that. Okay, Your Honor, thank you. We got the hearing notice. Okay, have a great day. See you next time. Right? Sometimes it's just that simple. Right? And yet it has enormous consequences. So how do you prepare? Right? How do you prepare? How do you know what's going to happen? How do you know what you're going to explain? First, you got to review the documents. The attorney, your lawyer, needs to review all the documents in the record. All right? They need to review the notice to appear. Remember, the notice to appear, the NTA, is the charging document in immigration court. It has allegations against you. It has charges against you. All right? You need to review that with your lawyer before you go to court. And you got to know, are those allegations correct? Right? Are they true? Are they false? Are we going to admit them? Are we going to deny them? Okay? You got to have the game plan for how you're going to plea to that charging document. All right? We also have to confirm address information. I didn't mention that, but we always confirm address information during a master calendar hearing. And fourth, you go in prepared, ready to decide, or already having decided what your next steps will be. Like, is your case ready for trial for your individual hearing or not? What other witnesses are you going to need? What other evidence are you going to need? What are you going to be gathering in the meantime to build your case? Right? You want to think that through. And if there's no evidence, okay, well, we got to at least do some declarations. We got to work and really explain what happened and why there's no other evidence. Okay? Or, and sometimes it's like, okay, if there's no other, like, physical evidence, let's get witnesses. Let's get character witnesses. Let's get a psychological evaluation. Let's get an expert witness that can explain what's really happening on the ground in your country. Okay? And you don't need all those things in place at the time of the master calendar hearing, your first one, but you certainly need all that stuff in place before the end of your case to maximize your chances of success. And so anyway, that's it, right? That's it. Short, simple, sweet, to the point. Don't go to immigration court alone. Have a lawyer. Don't go with an amateur. Hire a lawyer that's done this thousands of times. All right? Have a lawyer that knows how it works in immigration court. Have a lawyer that knows the judges, or at least some of them. Right? Have a lawyer that has won cases in immigration court. Like, that's important to improve your chances of success. So that's all I wanted to say. Thank you for letting me kind of share that. And so let me get into your questions here today. Tumbleweeds are real. I see you here. Great to see you. Thank you. El Midnighter. El Midnighter, maybe. Yeah? So, okay, how hard is it with this administration to get DACA renewed or to become a citizen with a record? Okay. So, if you don't have a record and you file for DACA renewal, it's pretty easy right now, actually. I mean, if you're qualified, then that's that. Then that's that. If you have a criminal record, that will always make a DACA renewal application more challenging because you're requesting deferred action, which is a discretionary benefit when there's any criminal record that can make it challenging, sometimes, depending on what the record is, it can make it impossible, right? So depending on what that record is, talk to a lawyer and have them give you good advice about it. Same thing with citizenship, although to have citizenship be risky, it would have to be a much more substantial record than. Yeah, anyway, talk it through with a lawyer first, review the record carefully first, and then they can give you good advice as to should you apply for your DACA renewal, or if you're already a green card holder, should you apply to become a U.S. citizen. Okay? All right. So, Sam, can I reschedule an immigration court date? Yes. All right. So let's talk about scheduling for a moment. There's motions to continue. That's a request. Anytime you want to request that the court change something about your case, you file a motion. All right? So a motion to continue is a request that they push the hearing date further out into the future. And a motion to advance is a request that the court bring the hearing date time closer into the present. All right? So a motion to continue takes it further out, and a motion to advance brings it closer towards the present. And both of those things can be filed if you need to change the hearing date for whatever reason. All right? Sometimes a motion to advance is absolutely mission critical to avoid missing certain deadlines, right? Sometimes if you have a child who's about to turn 21 or something of that nature, you've got to get your case heard early, then you need to do a motion to advance. Other times it's like, hey, no, we need to prepare, or we need to request, there's some other piece of the puzzle that needs to be put in place. It's not going to be ready to go on the date that you mentioned. We need a motion to continue, right? Okay, WISE 7774, can I file a motion to reopen my removal order based on being on the U visa wait list, or do I wait for a final approval? Okay, it's a good question. So there's not an easy answer to that. Okay? U visas cannot be filed in front of a judge. U visas are applications that are only heard in front of USCIS. Because of that, a U visa pending, and it doesn't automatically give a person the right to reopen their immigration court proceedings because it's not an application you can file in court. But in some instances, it can be an additional argument or an additional piece of the puzzle that might allow you to file a motion to reopen your case. And once your visa's approved, then that's a good argument to be able to reopen your case. Certainly after you have a green card through a U visa, then now that's very good. And hopefully you could get it reopened and dismissed or terminated before your green card is issued, right? And so anyway, yeah, so there are things that you can do. I would recommend getting your FOIAs first, reviewing the full record completely, and then making the decision. File the motion to reopen now, file it later, and how? What are you going to base that motion to reopen on? Okay? All right, good question, though. Thank you for asking it. So let's see. Jesus Sandoval, thank you for being here. What's better and faster, an I-130 from a husband or a U visa from a new boyfriend from domestic violence? Now, wait a second. Do you have a husband, or do you have a new boyfriend, or do you have both? It's just funny to see this question. If you're just asking the question, like if you actually have an I-130 from a husband and a U visa through a boyfriend, then the I-130 through the husband is faster. No question about that. But you got to show it's a good faith marriage, which is going to be hard to do if you also have a boyfriend. All right? So that's a tough one to answer. I would say talk to a lawyer carefully. Okay? All right, AZ, thank you for being here. So for an I-730 that was you received a transfer notice on your I-730, and it's transferred to an international field office, and the Department of State consular process it for approval. Okay, so your I-7, so typically they don't transfer the I-730 to the Department of State until it's been approved. So normally it's not a transfer notice, it's an approval notice. Okay, and so because the I-730 is the petition, and that petition needs to get approved. Petition for relatives of an asylee. And then once it's approved, then you move forward with consular processing. So good. I'm glad that you've received it, and looks that's good. You know, you should be able to proceed with your consular case to bring your spouse or your child into the U.S. after you won your asylum case. So good job. Okay, Potato, cool name. You say, if I make more than the sponsor, why do I need him on a marriage-based case? Good question. Good question. The law requires that the petitioner be one of the sponsors. Okay? So even if you make more than him, if he's the petitioner, you definitely need him. Okay? And that's just the way the law is written. Okay, so good question though. All right, those are all the questions that I see. So, oh, I see some more coming here in TikTok. So Jesus, you say both, and you're still married. Okay, like I would really recommend talking it through with a lawyer. If you're still married, but you're not really interested in the relationship, and now you've got a boyfriend kind of on the side or something like that, I would say, yeah, talk it through. The best advice is talk it through with a lawyer before doing anything. The marriage-based case would go so much faster than a U visa case does, but so much faster. But the U visa can waive a lot more things than a marriage-based case can. And so to give good advice, I mean, you could do, to give good advice, you would really want to talk it through with a lawyer, okay? All right, Asma, I see your question here. Hello, Otis. Are withholding of removal recipients still protected? Yes. If you've won withholding of removal, then yes, you are still protected. Okay, that is a order from an immigration judge. Yes, it's an order of deportation, but it's subject to a grant of withholding of removal. In theory, your deportation could be executed if there's a finding that your country has changed and now you're no longer in danger of return. But by and large, yes, once you win withholding of removal, like it's an order by an immigration judge that you cannot be removed, right? So yes, it is still protected. We are all nervous about the third country rules that are happening and whether or not third countries can accept deportees. And so I have not seen that they are doing that for people who have won withholding of removal. I have seen that they are doing that and accepting deportees for people who lost their case completely and have a final executable order of removal against them. Okay. Kunal Surana, can you also tell about what to expect for a VAWA-based interview? It's been 2 years since my receipt date. I have EAD and advanced parole with me. Okay, great. So a VAWA-based interview. You know, many VAWA cases are approved, or at least have been approved in the past, without an interview. All right, many VAWA cases have in the past been approved without an interview. Hey, and we know that the Trump administration is going to want to increase the quantity of interviews and increase scrutiny of applications. And so don't be surprised if you receive an interview on a VAWA case. And how do you prepare for it? The same way you would prepare any interview. Review the full application, all right? Make sure that it's all accurate and up to date. Be ready to talk about it. Review all the legal requirements of VAWA, all right? That you married in good faith, that you're a person of good moral character, all right? That you resided with your abuser, that your abuser had lawful immigration status, U.S. citizenship, or green card holder, all right? And that you filed the case within 2 years of the termination of the marriage. Like, review each of the legal requirements. You should do that with your lawyer. You should have a lawyer go with you to your interview, and you can answer questions that they will ask about all of those things, right? The good faith marriage component is a big one, right? How did you meet, and when did you fall in love, and how can you show that this was not just for immigration purposes, but you actually intended to form a life together? All those questions are real, and they will ask them. All right, tumbleweeds are real. All right, what types of FOIAs should be requested to see a person's record? Okay, this is a great question. There's lots of options, all right? In our office, on the vast majority of cases, we file EOIR, which is Executive Office of Immigration Review FOIAs, which is all of the immigration court process, all right, because we want an immigration court record. Customs and Border Patrol FOIAs, CBP. There's an office called OBIM, which is the Office of Biometrics and Identity Management. Very useful set of FOIAs come back when we request those, and we send fingerprints to that. The FBI, it's not technically a FOIA, but we want to get your rap sheets, right? The California Department of Justice, if you're in the state of California, especially if you've ever been arrested in the state of California. USCIS, ICE, the Department of State. All right, I'm trying to think. Have I missed any? I think those are them. So, and it depends. Sometimes we request all of those. Sometimes we're like, okay, you've never applied to anything before the Department of State before. That's not necessary. Let's focus on the other ones, you know. But yeah, that's the way it is. Thank you for asking that question, and good to see you. All right, everybody that's tuning in right now, thank you so much for being here. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. Thanks for tuning in to our episode today of the Empowered Immigrant Live. And I've got just a few more questions. I'll go through them, I'll answer them, and then we'll wrap up. And I really appreciate everybody for joining me here today for the Empowered Immigrant Live. All right, so thank you. So let's see, E-Keeper, I see your question here. You say, sir, do you have to put American stepdaughter's information in the beneficiary spouse and children? Yes. Yes, each of the immigration forms, they ask for all children, whether it's biological, stepchildren, adopted children, you know, yes, you want to list all of them. Okay, so that's important. Unke-mo4, thank you for being here. Would it be a problem if my husband's taxes was filed as HOH, head of household, got it, because I am not employed? Is it a problem? No, you're asking like for a marriage-based green card case, or for what type of case? No, it's not a problem for your immigration case. All right, if your husband filed taxes as head of household because you're not employed, it's not a problem. If that was honest, if that was the best advice from your tax professional, file taxes that way and look for other evidence to show that you have a good faith relationship. If we're talking about a green card based on your marriage, then have other evidence. Because sometimes we file the tax returns as married filing jointly as one of the pieces of evidence that you're in a good faith marriage. So if you don't have that, get other evidence. All right. Let's see. User 6339. Could the 43 visa countries travel ban be found unconstitutional in court? Or is it basically law now? I mean, in theory, it could be found unconstitutional by a court, but I doubt that will happen. All right. And the reason I say I doubt that it will happen is because the first travel ban under the first Trump administration wasn't found unconstitutional by any court. So I doubt it'll happen, but it's not law right at the moment. All right. It's been proposed. There's rumors about it. It hasn't actually been implemented. And so, and actually, it's not a quote unquote law. It's an executive order. And it could be changed, right, as things progress and things, it's not like a law where it's written on the books and requires both agreement by both sides of Congress, right, in order to pass it into law, which makes it much more difficult to change, right? This is an executive order, which means a new president could change it quickly and probably would, right? So, and you asked there, and is it likely that they would overturn or just uphold that executive order? Yeah, that depends on things that any answer right now is speculative. My advice is treat it as if it's going to happen and treat it as if it's not going to be overturned, right? That's my advice at this stage, because anything that says, oh, the travel ban is going to be shot down in the courts, it's just speculation. I don't know that that's right. Okay, I don't have any right now it hasn't even been created, right? There's only drafts that have been appeared on the New York Times and Wall Street Journal and things like that. It hasn't actually come out signed by the president yet. Okay. Very good. Few more questions, and then we will wrap up for the day. Maria Flores, your spouse was approved for an immigration bond, but the lawyer is saying I cannot pay for 30 days. Why? That's weird. That's weird. Normally, when an immigration bond is approved, you should be allowed to pay it right away. So I don't know. You should talk to your lawyer, get clarity about that. Maybe did the government appeal the approval of bond? That's an interesting one. All right. Let's see here. Beekeeper, I didn't put my U.S. citizen stepdaughter on the I-130, and I'm applying for an N-400, and I put her info. Could that be a problem? I mean, as long as it wasn't an intentional omission. It doesn't sound like it was intentional. It was a mistake. Mistakes happen all the time. You could just explain that when you get called into your N-400 interview. Yeah, so just that. It'd be messy, though, if you then became a citizen and now petitioned your stepdaughter. So if your stepdaughter's already a U.S. citizen, then that's good, right? You're not worried about it from that perspective. So anyway, yeah. Without knowing more about the details of your case, I can't give you better advice than that. But but that's my answer for today. Youssef El Alami, thank you for being here. You say, hello, sir. I have a final order of deportation. My green card was renewed, and my driver's license also was renewed, even though I am in Florida, and that prevents a person with such an order to renew driver's licenses. Okay, you're in an interesting situation. You're saying that you have a final order of deportation, but you also have a green card. Did I hear you right? You have a final order of deportation, but you also have a green card? Because if so, you got to fix that, right? If you won your green card, and if your green card is lawful, you got to file a motion to reopen the final order of deportation and terminate that thing, right? If your final order of deportation is the one that is accurate, then legally you are no longer a green card holder. Like you got to, there's a problem, there's a conflict between those two sentences. You have a final order of deportation and a green card. Those two things don't go well together. All right, something is off. Talk with a lawyer. Feel free to call our office. We could do FOIAs, get to the bottom of it, see if we could reopen your immigration case and terminate that removal order so that you don't have to worry about this issue anymore if you have lawfully received your green card. Okay? All right, so then Maria Flores, he mentioned DHS had. Oh, your spouse was approved for immigration bond. Yeah, so DHS appealed the bond decision. I mean, maybe that's right. Maybe that's right. I would have to look that up. That's a new one for me. If you're saying if a judge grants you bond, but DHS reserves appeal for 30 days, can you file that bond and get out? You know, I think you can. I don't think you have to wait 30 days. All right? Don't hold me to that. I'd have to research that. I've come across that issue in the past. It's been a while. All right? So, but I think, man, if there's any way that you could pay that bond and get him out of there, pay that bond, get him out of there. All right? He just might be re-detained if DHS wins their appeal. But man, it'd be so much better to get him out now while you can. Anyway, thank you for asking that question. Matt Dykes, thank you for being here. Is it safe to travel on a VAWA-based advanced parole just for a month and come back? I mean, unless you're from one of the travel ban countries, yeah, it is. You should be okay. You know, I'm going to do an episode next week. Maybe actually not next week. I take that back. I'm going to do one of my next episodes is going to be about things that are happening at the border. They're screening people's cell phones, right? They're looking at social media feeds and stuff like that. So you want to be cautious about, don't travel with, I don't know, marijuana leaves in your photos on your phone, right? That's not good. Don't travel with social media. Even right now, it's like don't travel with social media posts of you in a protest against the war in Ukraine or against the tariffs or against the Trump administration. I mean, I'm a huge believer in the First Amendment, and I hate to say this, but I also want to prepare and protect my clients, right? They are screening for that type of stuff at the airport. And so if people have a history of protesting against what are currently interpreted as U.S. foreign policy interests, it potentially can cause a problem. Other than that, have a safe trip, okay? Have a great time. Come back in a month and let us know how it goes. All right. I think those are all the questions that I've got for today. So thank you all so much for being here. Really appreciate each of you. Oh, Valentina, I see you have a question that came in. Can you travel if you have an added stamp and not the physical green card? I mean, yes. Just also have proof that you filed the replacement or the renewal. Have some kind of explanation as to why you don't have the physical green card. The added stamp in your passport actually serves as evidence of lawful permanent residence as well. So yes, you should be okay. All right, everyone. Thank you all so much for being here. You know, my empowerment tip today, which I have, I like to empower folks. Part of it in immigration court is this is part of my own belief. All right, you got to believe in yourself. All right, when you're going in front of a judge, when you're actually facing deportation, right? I've got a hearing later this afternoon. That's why I was talking about the topic of immigration court. You got to believe in yourself, right? You got to believe in your case. You got to believe in your value. You got to demonstrate that. You got to show that. And for me, it's true every day coming as like a business owner. I got to believe in myself for my team, right? And I got to believe in the work that we do, and we're doing good work for the community and for people. We love what we do, right? But it's true as a human being. You walk down the street, you want to believe in yourself. You believe in your value, believe in what you're capable of, right? And it's true for an immigrant in immigration court facing deportation. You got to believe in yourself. It's like we can overcome this. All right? And get a good lawyer. And if my office can help you in any way with that, we're here to help. We'd love to help. Okay? So thanks, everyone, for being here. I really appreciate each of you. My name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. I wish you the very best, and make it a great day, and we'll see you next time on our next episode of the Empowered Immigrant Live. Thanks a lot, everybody. Take care. Bye-bye.